Evie, you let me know when we're good to go. Awesome. I can't hear you, Evie.
Now?
I can hear you now.
Yay, thank you. I had it on my headset. Hello, everybody. Take it away, Jacqueline.
Awesome. Hi, everybody. Welcome in. Sarah is out on vacation living her life by design today. So I will be your MC for our risk management meeting. So let me first start off and just jump right in by doing some welcomes, which is always exciting, and welcoming in Ken Bray. Welcome in. We are so excited to have you on board at KW San Diego Metro. Round of applause for you in the virtual world. And I'm going to hop right into our market moment. I don't want to delay. I know Brooker Bob has a lot to go through today. And for our market moment, if you have something, feel free to raise your virtual hand or take yourself off mute. I'm looking in particular for stories that you either recently dialed up or doubled down on your lead gen and you're finding business that way, or you helped a client solve something with something you haven't done before. So we were talking earlier about 2-for-1 buy downs and all kinds of things that are available as the market is changing. So raise your virtual hand if you have an example of a client that you just got into business recently. And while you guys are doing that, I just wanted to remind everybody that one of the reasons we do this market moment is because you can share our stories. So our office stories are things that you can then share so that you are enticing people to call you and have real estate conversations. So we were just talking about that in the office yesterday. If someone shares a story, it's a great way to get on social media and say, hey, this happened to somebody recently in my office. Let's have a conversation. Let's dive deeper to see how I can help you. So let me pause there. Who has a market moment story for us?
I have one.
Awesome. Go for it, Peggy.
Thanks, Jacqueline. I noticed that a lot of properties that are on the market that are vacant and they're just kind of like empty rooms. And I just wanted to mention that when I did, like I do a kind of a circle when I get a listing, I do a deep cleaning, staging, photography, and drone. And I do that like it's like my business measure, for my client. And I'm noticing that I'm getting a lot of traction that way. And I just want to encourage people to really take a look at when they get a listing, doing everything they possibly can to present because it's the presentation, the price is super important. We talk about that a lot here. But also the presentation, I'm noticing, with the feedback that I get from the buyer's agents, that that's super important to them too. So I just wanted to make a notice. I mean, I had something on the market. We're just getting an offer today. We just put it on the market the other day. So it just really works for us. Thank you.
Awesome. Really good one, Peggy. And then I think, Kevin, you might be on here. I'll call you out just because I know that you started doing your home buyer seminars again. And I know that you had people show up and you're now working with those leads. So I don't know if you're on here and want to say anything about that, but congrats to you for implementing some new lead generation.
Yeah, I'm sorry, I'm driving right now. Yeah, thanks. It was a good turnout. We had 5 people, and 3 of them were just from the social media post. I had no clue who they were. Matt didn't know who they were. I don't know where they came from, but I'm glad they came. And so we'll be following up with those. I've already got them in the database or in command and on a smart plan. So we'll be following up with them shortly.
Awesome. Great job. Okay, good stories. I love that. Let me pass it back over to you, Evie. I know you have some events to go over.
Yes, ma'am. It'll just be quick. Just for this week's, we still have Language of Real Estate with SJ via Zoom at 8:30 tomorrow. And then our dear Director of Tech, Nick, will follow right after at 9:30 via Zoom. He's going over KW Command tips, making designs. So if you want to learn about that, please come and join Nick via Zoom. And then right at 11 a.m., Broker Bob, his Thursdays with BB with guests Kevin King will be there tomorrow at 11 via Zoom as well. And then in person only, our dear Matt Thornburg will be going over how to lock in your next 30K commissions with buyer. And that's going to be in the training center in person only. We will not be recording that. So if you don't want to miss that, come and join him at 1 o'clock tomorrow. And that's it for this week. But I do wanted to pitch in, Bold is back for Steps 2 this coming Monday. Same place, Marina Village. If you haven't registered and would like to attend Bold, you have any questions and need help with that one, please come and reach out to me or any of the staff and we'll be able to walk you through the registration. And next week is our Halloween potluck. We've been kind of waiting for this to hold our annual social events. So we will be kicking off Ashley's in-person only market stats with the Halloween potluck at noon. So everyone's invited, come in costume. Let's have fun in the training center. Bring in some snacks and I'll send out an invitation so you all can kind of just let me know what you're bringing. So we're not doubling up on that. Noon, Halloween potluck. And then Ashley's stats in the training center in person only. So lots of exciting things. We also have contracts coming up. I'll be posting all of that. I know there's a lot of training coming up. So just keep an eye out on our Facebook page. And I'm also blasting emails constantly to remind everybody. Thank you, Jacqueline.
Evie, I'm excited to see everybody that's going to Bold on Monday. I will be there. I'm excited to see you. I'm also excited to see everybody at the Halloween potluck on Wednesday for stats. So that is all very exciting. I'll add one more to the list. The Halloween contest we talked about last week is live. So that is on our Facebook page. That is so that you can reach out to your database. It's a free contest to you. It's just a mechanism that you can put on your social media. So you start getting in conversation with your people. So check Facebook for the Halloween contest. It's live through October 30th. And let me pass it over to you, Broker Bob, for coaching spotlights.
Thank you, Jacqueline. Happy Wednesday, KW Metro. Hey, let's give a shout out for agents, great agents doing great things in the great coaching program. On Team Alicia, Eric Harris closed another escrow. Great job. And our own downtown Deborah Brown got a new listing signed as well. Great job, Deborah. And then Sam and Yanni closed another escrow and opened another escrow the same day. Great job for those two. Congratulations. And Coach Vinny Andres opened up another escrow from a buyer he met at his open house. Great job converting at the open house. And finally, on Coach Deborah's team, Karine closed another escrow on her Escondido listing. Congratulations, and I'll be back in a bit with risk management topics.
Excellent. Thank you, Broker Bob. Let's pass it over to Movement Mortgage. Who do I have from Movement Mortgage today?
Hey, everybody. We wanted to let you know that we're going to have Nicole Soares, our credit repair expert, come on the team meeting and be our main speaker on November 9th. She's a fantastic resource that we use to help your buyers that may have a little credit challenges. A lot of loan officers don't even use resources like this. I think it'll be a great tool in your toolbox to help people either fix something on a more immediate basis or at least get them on a roadmap so that they can get into a house 3 or 6 months down the road, depending on what they need to have updated on their credit report. Nicole is the most fantastic credit repair person, super knowledgeable. She used to work for FICO. She's very reputable, and unlike so many other credit repair companies that are out there who will just like sign you up to take your monthly fee and promise the moon and never deliver, I've sent my own family there, my little brother, and she's fixed his credit and just done a stupendous job, outstanding job. So I want to help connect her with you all so that you can help those credit challenged buyers become buyers in the market later on down the road. And we look forward to bringing her to you as our guest speaker or featured speaker on the November 9th team meeting. With that, thank you so much for this time to talk. I hope you all have a great afternoon.
Awesome. Thank you, Wes. And I will share something with all of you that Wes and I were talking about earlier this week. The Movement Mortgage team is a great resource if you want to hear what's been happening successfully on the lending side. reach out, connect with them, ask what's been working to get buyers under contract or what some of the sellers have come up with. That's a great resource for social media content for you, so that if you're trying to figure out ways to entice people to give you a call, that team is really great at giving you ideas of how to speak about the world of what's happening right now in rates and making plans for the future. Even if it's not an immediate purchase right now, you can get them connected and get them on a plan so that you have future business as well. So thank you for everything you guys do on the Movement Mortgage team.
Thanks,
Bridget.
Jacqueline.
Of course. Bridget, are you here for Culture Committee?
I'll speak, Jacqueline. Just a quick one, nothing really major. We did just save the date for our holiday. I know we're talking about holiday already, which is kind of scary. Holiday party it has been booked, and we're in the process of the planning. It'll be Friday, December 16th. It'll be a block of 7 p.m. to 10 p.m. at Tavern Bowl. You can bring your kids. Everyone's invited. So more details to come. Just wanted to put it out there to just save the date. So thank you all.
Awesome. Thanks, Evie. And so far we are on time, which means we get to do property pitches because we stayed on our schedule today. Anybody have property pitches? Nobody has a property pitch? Anybody have buyer needs?
I couldn't get off mute. Sorry.
There we go. Go for it.
I have one that's going live. I've mentioned it before, but we were just getting it ready and getting the tenants out. But they're out already. So it's going live November 4th. And the address is 9860 Dale Avenue, Unit E2 in Spring Valley. It's a condo, 222, I believe. Hold on, sorry. But yeah, that's in Spring Valley. But sorry, it's a 2-bedroom, 1.5 bath, 1,060 square feet. That's it.
Very cool. And if you want to throw it in the chat too, Izzy, so people can follow up and connect with you on that, that would be awesome. Anybody else? Property pitch or buyer need? No buyers, no sellers. Going once. Okay. That's your moment to shine. If you missed your moment to shine because you were driving and you couldn't get off mute fast enough, but you get to a safe location and you want to throw it in the chat, go for it. I'm going to go ahead and turn it over early to Broker Bob. I know he has a lot for risk management today. So Broker Bob, over to you, friend.
Thank you, Jacqueline. Happy Wednesday, everybody. So great to see the 1, 2, 3, 4, 5 faces of agents so far that have their video on. And if you're the one that has no video, I still see your face, your picture. What is everybody doing? No one's participating in our team meeting today, or you're just being shy? Anyway, glad to see you all. Hopefully today will be a great risk management meeting. I can make this stuff as boring or as exciting as possible. Without further ado, let's get into it. So I'm gonna share my screen and get going on this with the slide, because the slide kind of helps me keep on track. All right, so this is your October risk management meeting for this month. What does that mean? Anybody want to take a guess what that means? It's a very spooky time in the real estate industry. So just remember that, okay? You know, I'm trying to give dad humor because Mark gives it to us every day at the leadership meeting. So I'm giving with his jokes. So I'm giving some dad humor today. So it's a spectacular. I didn't put any graphics on my PowerPoint today, but I figured you'd be able to be okay with it. So what are we going to cover today? I'm going to review a few risk management topics that I've learned at SCAR that's important for you to know. We're going to review what we call the 6 statutory disclosures. I have another word for them, but these disclosures, if not delivered, can actually cause havoc in a transaction even after a buyer's released their contingencies. We're also going to talk about items included and excluded. And we'll get to that one in the correspondence log creation as well. Okay. Here's what we talked about at last week's SDAR risk management inside info. It's not really inside info, really, because it's been in the papers, but the no-fault eviction moratorium in the city of San Diego has expired, although significant protections for COVID-related non-payments still apply. What does that mean? Okay. So remember back when the Board of Supervisors and the city of San Diego put in an eviction moratorium, meaning if someone is in their property, that person cannot evict that tenant, even if they wanted to sell a house, to sell that property, or take it off the market, or let's say they wanted to move back in. They virtually made it impossible with their restrictions. That ended September 30th of this year. So how do you need to consult your principals still? Is there still might be some local municipality, in other words, other than City of San Diego, maybe Chula Vista has something different. And we don't track that separately because it's constantly changing. It changes all the time. So my recommendation to you is if you have a listing prospect that a seller wants to sell a tenant occupied property and they haven't given notice to the tenant, you are not able to help them at that point because you can't serve as a property manager for them, but you need to guide them to speak to a qualified California real estate attorney that specializes in, they don't really need to specialize in eviction proceedings, but it's helpful for them if they have that experience. But they have to be a real estate attorney. They can't be a medical malpractice attorney. It has to be real estate. And then have that attorney guide them as to what steps they as the landlord owner need to take in order to have the tenant move out of the property. The best thing is, if you've ever been a listing agent, you know this. If you have a tenant in place that makes it impossible to sell, best to have a tenant occupied property be vacated prior to close of escrow. Landlords could do a lot of things like cash for keys, where they give an agreement to the tenant, say, hey, if you move out on a certain date, even though you can't, we'll give you some cash. We'll give you some extra cash. Or if you don't want to move out and you want to work with me through the sale process, we'll reduce your rent by X dollars, but we'll apply it at the end of when you move out. Okay. So a lot of that stuff, but that is the news on that. Okay. And then I say this every time because every week we have new people that show up at our office and they're brand new agents. So I want to always let them know your fiduciary responsibility is to your client. You put them above all others. And that means one of the most important things for you to do is to guide them through the real estate transaction. And we do a really good job on our compliance team with our director, Mark Miller. Thank God we have him because he is really good and detailed in his review messages when you submit a transaction on how to guide your client on why this form is necessary, why you need to do this way. We're there to make sure. One thing we don't want you to do is get sued, because what do they say? If they're suing me and you in the office, is your agent never told me that. So those review messages are really intended to help you guys through the process. One of the things with our, you'll see on the new messages, Mark is sending that out starting this week. Compliance reviews are intended to be learning experiences, never a reprimand. Working in real estate is an ongoing practice, and we all are learning in the practice in real estate. I bet you never thought when you want to become a real estate agent that you have to know a little bit of the law and contracts, etc. But that's necessary for you to have that knowledge. And our intention and goal is to always help you make sure you have all the knowledge you need armed to make you a better agent. By making you a better agent, you're more valuable to your client. By being more valuable to your client, they're going to reward you with repeat and referral business. And I can't tell you how many times that we still do get people that say, hey, thank you very much, Mark or Robert, that really helped me with this client. And because of that, they rewarded us with some more business. Okay, so the review of the 6 statutory disclosures that can cancel a transaction. Here they are. It's the TDS, otherwise known as the Transfer Disclosure Statement, the AVID, the Agent's Visual Inspection Disclosure, the SPQ, which is the Seller Property Questionnaire, the NHD, the Natural Hazard Disclosure, which is provided by a third-party company, and then the LPD, which is the lead paint-based I got a double thing there, lead paint-based disclosure, and then the FHDS, Home Fire Hardening Disclosure and Advisory, with its accompanying form to help fill out that form. It's called the DSD2, and we'll review that form as well too. And I did talk about this, I think, at the last meeting, but I don't think I had enough time to really go through this in detail. This is the number 6, the FHDS, is a newer form because basically it addresses the fact that California is a tinderbox. And if you have a home that you're selling in a high fire area, there's certain laws and requirements that that home has to have. And through this process, it's been a law that was created by the California State Legislature, which means then the Department of Real Estate had to implement it in conjunction with CAR, California Association of Realtors, and they put a new form together. They send it out without any proper guidance. Nobody knows how to fill it out. The one state entity, which is the Cal Fire Department, doesn't understand it as well too. And it was an absolute disaster when this went out. And it was a lot of concern with agents when Mark started writing review messages about this is what you need to do and how you need to do it. And sometimes that meant going back and backtracking and have the buyer or seller either re-sign something or seller change, modify something on their disclosure. Because now, and we'll go through that form so you can see that as well too. So let's just get into you all know, if you've been in a transaction, the real estate transaction, TDS, that's been there for years. I don't really need to review this form, but this is the one form. And so when I say these are the 6 forms that if they are not given in a transaction, unless the seller is exempt from having to give it, and you get into the transaction, and let's say the buyer, you go through the process, and the buyer removes all their contingencies. And then on the 12th hour, right before the close of escrow, the listing agent saw, oh my God, we didn't send over the TDS. Let's send that over. And it's really any one of these forms, but I'm just using the TDS as the example right now. The buyer has the right of rescission, meaning they could actually cancel the contract, get all their deposit back, leaving the seller now having to go put the property back on the market if the buyer decided they wanted to do that because there was something in the TDS that wasn't something that they were aware of. Now, usually the TDS is always given in a transaction. It's the FHDS and the newer forms, and the AVID, the AVID. The AVID is industry sickness on being able to fill that out in a timely manner. But a law changed in 2019, I believe, where it made it gave the AVID the right of rescission if it was not accompanied with the TDS. And you know, all know on page 3 of the TDS, there's this little section right here. If you're the seller if you're this listing agent, the undersigned based on the above inquiry, blah, 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 blah. And you see 3 check boxes. See attached AVID, or agent notes no items for disclosure, or agent notes the following items. So our brokerage requires the AVID because that's a more detailed form. And it's also a really good protection mechanism in case there's ever any litigation or mediation arbitration that we end up in. So my point on that is make sure you get your AVIDs filled out very early in the transaction, not the 5 days prior to close of escrow. Because if that buyer has removed, and if a seller does not give their listing agent does not give their Avid with the TDS, that's the right of rescission. It's not the right of rescission if a buyer's agent is late on their Avid. It's coming from the listing side. So keep that in mind with the Avid, and then your or TDS and your AVID looks like this.
Hey, Robert, this is Dan.
Yes, Dan.
Hey, can I just throw in a pitch for as California Association of Realtors? They provide a service which is called Glide, which you can use for doing the TDS and the SPQ. And if agents aren't using that, I highly, highly recommend it because there's all those teeny tiny little check boxes, but it's free for us to use Glide. And it essentially send a copy to yourself and practice using it so that you can know what your clients will go through. But it literally is a website that brings you question by question, and you check yes or no and fill in information, and it populates the form for you. It makes it so much easier for your sellers to complete, and I highly recommend it.
There's Danny, there's actually a couple different ways you can do that. Glide, our office has Glide Broker Edition because Glide Personal Edition used to be a car member benefit until Glide was purchased by a competing brokerage, and they no longer have that relationship. But we offer Glide Broker Edition. If it's something that any agent wants to try, they can contact us and we will, set up an account for them if it's not already set up. There's also a feature within Zip Form called Zip Community, and it's accessed by the share button. Share, and you can invite people to, complete forms within it. So there's a number of ways to do it. It's a little bit lengthy to talk about right here, but if anyone has questions, please reach out to us.
Thank you, everybody. Dan, yeah, that's a great point, Dan. After just selling my home in San Diego, I went through and did it with Glide, and it made it pretty seamless and pretty easy. Great information on that. Okay. And then of course your Avid, that's a whole nother class. And for safety of time, we won't be able to do that train on this, but this is what the form looks like. And an Avid is an agent's visual inspection. It's not you're not turning on and off lights, running dishwashers, running heaters. It's visual. What do you see visually? And we can go in another whole class on how to fill that form out properly. And then the SPQ, the Seller Property Questionnaire, is this form right here, the SPQ, and it pretty much is a complement to the TDS, but it's not a substitute for it. So that's the other form that needs to be filled out as well. And then the Natural Hazard Disclosure Report is where you get it from a third-party company like Disclosure Source, all those great companies that come into our office. And that disclosure report actually has within it, and most of them do now, is whether or not that home is located in a high fire zone. It will spell that out in the NHD company. And I'll go through also how do you also find out if you don't have the NHD company as well too. And then the lead-based paint disclosure, pretty self-explanatory within itself. So I won't need to go through that one. Let's get to the home hardening note. So the home fire hardening disclosure and advisory, and I'm trying to dumb it down as much as I possibly can so it's easy to convey to a seller, is in California, there's new laws that have said they're either vegetation management laws or laws that say if you have a home in a high fire area and you are subject to those high fires, you have to have a space around your home, a clearing, so that if there ever is a fire in this area, it will limit the opportunity of fire to get onto to the actual property. So you got to clear out shrubs and trees and plants that could be high fire. So, and that is now the responsibility of every home in the state of California that is in this and in these zones. It's also it's not a point of sale requirement, but it does require that buyer and seller come to an agreement about who is going to take care of it if it's not taken care of prior to close of escrow. And what we're fearful of as what I'm fearful as your broker, and when this form came out, I'm like, this is going to cause probably troubles down the road because of non-compliance on disclosure requirements, et cetera. But people not knowing how to fill this out or guide a client, they're going to come back and say, your agent never told me that. My biggest fear is that a buyer comes back and says, your agent never told me that I had to pay $20,000 to remove all these shrubs around my home. And I'm fearful of that happening because, and it's no fault of the agent because this was a new form. It was implemented poorly by by the government. And unfortunately, that's where we're left with right now. But let's get into that form so you can, actually what I really want to post up first is the DSDT. The DSDT is the Defensible Space Decision Tree. So what this form is for is if a property is required to have this form, it's because it's a property that contains 1 to 4 units. The seller is required to complete a TDS, and the property is located in either a high or very high fire hazard severity zone. If any of these 3 conditions are not met, then the FHDS does not have to be completed. So basically, it would be an exempt seller that wouldn't have to provide that form. And very rare that there's exempt sellers. In most cases, actually, some people that claim they're exempt really aren't, especially if they have knowledge of the property. So it takes you through 4.1 steps. And right here at the very top, before you get into the question, if any step of the DSDT below instructs the seller to then sign form, no further questions should be answered. So basically what this form, the DSDT form will do, it will help the seller fill out the home hardening form. Because the home hardening form, when we get to it, you're going to see it, how confusing it is. So what's happening now with our compliance team and with the TCs is they're sending this form out to the seller first to have them fill that out. And what would be really helpful is if it's part of the listing documents at the very beginning, so that you have this information up front that you could just hand it to the transaction coordinator or whoever's managing the file and then give it to them. And then they know then they could send how to send set up the home hardening form. So basically step 1, is this property located in an area where a local city or county vegetation management ordinance requiring defensible space around the property applies? Hereafter, defensible space law. And then you go through, if yes, then check the box is on box 3A and then go to step 2.
Robert,
So
can I ask a question?
Yeah, hold on. What that means is if yes, check the box is on 3A, which is the FHDS form, and then go to step 2 on this form. If you check it is not the box in 3A, then go to step 4, or if seller does not know, see the next column and find out. Okay, who had a question?
Dan did, but I think you just got so like that very first question, like most sellers have no idea the answer to that question. So
Yeah,
that's where the NHD comes in, right?
The NHD comes into play. You have to have the NHD before you actually know that you even need this form. Okay, so if it's not in a high or very high fire zone on the NHD, then this is not applicable. If it is, then this form is applicable. But this step 1 is addressing if there's any local city or county vegetation management, not state, which is what the NHD defines. And the answer to this, step 1, is always going to be yes if your property is located in the city of San Diego or in the county of San Diego, because both have local vegetation management ordinances. So if it's in a high or very high fire zone on the NHD, you use this form, and the answer to step 1 is yes. It's always yes.
And Mark, you bring up a good point, because you mentioned San Diego, City of San Diego and San Diego County.
Correct.
And I know, Dan, you sell properties in Riverside County, and other agents here also sell properties in Riverside, Orange County, LA. So it's the responsibility of the agent to be able to find that out in those specific areas as well too, and understand that. And even if you didn't have the NHD, on the right-hand side, how do you find out if it's subject to local defensible space? You can contact CAL FIRE at www.fire.ca.gov/dspace. So the resources, regardless if you don't have the NHD report, or you can contact an NHD rep and see if they can give you the answer.
And on the local ordinances, if you're dealing, let's say in Temecula, you could just say, search local vegetation management ordinance Temecula and find out if there's a local ordinance in that area.
Yeah, because he mentions Temecula, which is in Riverside, and a municipality might be different than the entire county. That's why this is so freaking confusing, you know, because we allow agents to go out and sell in various counties, and we can't keep up on new laws that might be implemented by a municipality. So it's incumbent upon the agent to understand that. And then the step 2, does the seller have a report prepared by an authorized defensible space inspector? If yes, and the report documents the property is in compliance, then check box 3B2 and 3C5, and if applicable, complete, then sign form. If that's the answer they give, and then they stop, they don't need to go on anything else on the DSDT, and they know exactly how to fill out the defensible space form, because it just tells you which boxes needs to be checked. And as Mark said, box 3A is always checked yes if it's in San Diego County or City of San Diego. And then step 2, you check box 3B2 and 3C5 and then stop, and then the seller signs the form. But if they didn't, if the report documents that the property is not compliance or compliance status will no longer be effective, then check paragraph 3B3 and go to step 3. Or if no, paragraph 3B1 applies and go to step 3. So then the process continues. So without going through this very wonderful, boring form, this is the process that a seller is going to go through and fill out, so that they understand how to fill out this lovely form. And this is where a lot of agents and sellers get confused, because as Dan, thank you for saying that, Dan, sellers don't know. Sellers don't know. So my job here is to train you guys so that you know how to consult with them. That's why I'm very grateful that I have 51 people on today's call walking through this with us, so that they understand how do you consult with a client in a high fire hazard zone area about how to fill out this form and not look like you don't know what you're talking about. That's why you come to risk management and be bored to death once a month to listen to Broker Bob and Mark go on and on and on about these forms. Okay, but if you remember, let's go back to the questionnaire right here. Step 1, if yes, check the box 3A. So that's right here, and they would come to this form, check box 3A is or is not. Based upon what they
possible to do one more zoom in just to make it a little more legible, or are you at max zoom?
How old are your eyes, dear?
Eyes are getting old.
And again, if we're talking about local compliance requirements here, that is always going to be yes, or property is, check the box that says is, if it's in City of San Diego or County of San Diego.
So Mark, what have you seen now that you've done this about? How long has it been? How long has this been out?
This FHDS form, I believe, was released the beginning of this. No, it was released in June, but it went into effect July 1st.
So what are you seeing on compliance reviews where agents are having the biggest problem on this?
Not knowing that there's a local vegetation management ordinance in 3A. There is, again, not to beat it to death, but there is. And so 3A would always be checked, yes, if it's in City of San Diego, County of San Diego. Sometimes 3A is left blank. sometimes as you're representing a buyer and the seller sends this form over to the buyer's side and it's not applicable, then I've seen it signed. The parties are making an agreement here. If it's not applicable, the buyer doesn't have to sign this form. So it's important for you as a buyer's agent to know if the property is applicable for home hardening and defensible space.
That's a very important point. So even if you're not the listing agent, you're on the buy side. If you're going to show a property in East County in Humboldt, obviously that probably is in a high fire zone area. You would know that, but you wouldn't know it if it was in downtown San Diego, whether or not it is in a high rise.
Yeah, I mean, there's also areas where there's canyons, like in Bankers Hill, and those, you'd think, oh, it's nowhere near where there's going to be a fire, but there could be a fire in a canyon and it could be designated as a high fire zone. So you really have to check the NHD.
Can we also address the difference between single family homes and condos? Because like most condo people don't have any control over these forms. So can we clarify how that should be handled?
Yeah, I'll correct one thing that you said, that the seller in a common interest development or in a homeowners association does not have control over the management of vegetation, as an individual, but they are still legally responsible to fill out this form. The homeowners association is going to be the entity that's responsible for the defensible space for the complex and all the common areas. So it's not that the seller still needs to complete the form, even though they don't have the responsibility. It's a oversight by the legislature to not have created an exemption for sellers in homeowners associations or common interest developments. But this is what we have with right now, and until the law is changed, the seller still needs to complete the form if it's in a very high fire zone.
Hey, Mark, is this required for trust transactions or is it one of the exemptions?
If your seller in a trust transaction is a successor trustee and they would be exempt, not completing a TDS and an SPQ, but instead completing the exempt seller disclosure, the answer is no. Even if it was in a high fire zone, they would not have to complete the FHDS. So the prerequisites again are TDS 1 to 4 in a high or very high fire zone, and then the section 2, the home hardening section, is only applicable to homes built prior to 2010.
And to tag on to that too as well, it's very, even some sellers will say, if there's, like Mark said, the case was if there's a successor trustee that's selling the home because maybe it's their parents' home, but they also lived in it. If they lived in that home with the parent, they have knowledge. So they're really not exempt from filling out those forms if they lived in that home. So if you're representing someone that's a successor trustee in a home it was their parents or something like that, they're not exempt by just by a given. They might actually have to be required to fill it out because they have some knowledge, especially if it was aging parents that they were there, they helped them manage the house, their affairs, et cetera, et cetera.
I think that listing agents have to ask the question of, maybe they're exempt, but maybe they're not. So is there any harm in giving them the TDS and the SPQ? No, because if they are asked all the questions and all the answers are no, that's fine. They have been given the form and been able to complete the form, and all the answers are no. But if you don't give them the form and you only give them the ESD, there's still a section in the exempt seller disclosure ESD where they can disclose material facts, but it doesn't ask all the questions that the TDS and SPQ does. So why not give them the forms? If their answers are all no, so be it. A classic exempt seller disclosure seller would be like an REO company. They have like no knowledge, bank-owned property. They would have like no knowledge of it. Or maybe a probate where a third-party administrator has been assigned to manage the estate or administer the estate. That person is probably more likely candidate for an ESD, an exempt seller disclosure.
Okay, and then section 3, this is the section C. This is the section that you need to understand, because what it deals with is which party shall obtain compliance with the applicable state or local defensible space requirements. That's what this whole section covers. Basically, it's either the buyer responsibility because there's no local ordinance. It's the buyer responsibility, a local vegetation management ordinance in effect, buyer responsibility, which does not require compliance, or seller responsibility for selections 4, 5, or 6. So this is where I'm fearful where this gets to the point and the buyer and seller haven't filled this out. It hasn't been filled out properly. A box wasn't checked. And then there's nobody that's determined who's going to be responsible for the compliance. And this is probably where it's going to come back and bite us in the butt down the road, because this wasn't formed. So when Mark was sending out the review messages, it meant probably backtracking and going back and telling the seller, hey, this was filled out wrong, or to the buyer, hey, we need to determine who's going to be responsible for this. And then it comes to find out if you're in a situation where you help this buyer buy this dream home, and then they find out that the seller's not going to pay for the defensible space to make sure it comes into compliance, and they're going to have to spend 20, 30, 40, 50,000 doing that, you might have lost the deal. That's why it's really important you understand this going into the transaction so that these 12th hour things don't happen.
This is just another example of the things that the buyer's agent needs to advise the buyer to investigate. It's just like they would investigate having a termite report done if the seller didn't provide one, or having a general home inspection done. This is defensible space is another thing that the buyer needs to investigate.
And then where are the termination rights located in the RPA? Because I know every one of you reads the RPA every night before you go to bed, and you know it backwards and forwards. But it's under section G called termination rights. And if any disclosure specified in paragraphs 11, A, B, C, or D, which is all the forms we just reviewed, or subsequent or amended disclosures to those just specified, is delivered to the buyer after the offer is signed, buyer shall have the right to terminate this agreement within 3 days after delivery, in person, or 5 days after delivery by deposit in the mail, or by electronic record or email satisfying the UETA Act, by giving written notice of rescission to the seller or seller's authorized agent. If buyer does not rescind within this time period, buyer has been deemed to have approved the disclosure and shall not have the right to cancel. So from the buy side, you got to pay attention to make sure that you tell your buyer within 3 days, if they got it electronically, they have to determine whether or not they want to cancel. And if it's on the 4th day and they come back, we wanted to cancel. Oh, it's too late. What? You never told me that. Now they got a case against you. Okay. But section G of the contract is the termination rights in relationship to the dirty 6. Mark hates it when I call it the dirty 6, but they are. They basically could be a 12th hour drama on an escrow that you're just at the finish line and then it doesn't make it. Any questions on that whole topic or comments?
There's a couple of questions in the chat that maybe we can address. One was, is this similar to water conservation considerations? And yes, it is similar in the sense that we used to have a point of sale requirement in City of San Diego for homes that received water from the water department, City of San Diego. That is no longer in place. That was repealed, I guess, in February of this year. So that point of sale requirements no longer required it, but the seller still required to tell the buyer if the home is equipped with water conserving fixtures in the TDS and the SPQ.
And the only other way different is a shower head only costs about $50. Clearing defensible space around $1 million home is going to be $100,000. So,
And Amy asked a question, is that shouldn't this be in the RPA? And I'm thinking she was referring to the fire hardening, and that is, or defensible space fire hardening, and it is addressed in RPA 11C. C like Charlie.
all right, so hopefully we've covered that topic to help you guys navigate through that. And Mark's really good with his review messages. When you get those review messages, when it comes to something, he talks about the home hardening or anything like this, read it and act upon it. It's not meant to, as we said, it's never a reprimand, but it's how to make you better and how to help you learn. Okay.
And reach out and ask questions if you have them. You know, when your sellers present questions to you, you know, that's what we're here for, to help answer these questions for you.
So I can't count the number of times that we've had a transaction closed and a buyer's agent will call me and say, Broker Bob, my buyer moved into the house and the seller took X, the seller took Y, did not leave it. And this is where big problems can start to happen. So Section P of the contract talks about items included and excluded. Meaning, are they a part of the contract or not part of the contract? And where the gray area happens is whether all items of the purchase of the home, if they're real property, meaning they're attached to the land, is considered included with the property. Personal property, sofas, dining room tables, or something like that, that are not attached to the land are typically not included. They're excluded, but they don't have to be listed. But where the gray area happens is what can be considered personal or real property if there's a vague question about it. And some of the things that will happen will be water fountains in someone's backyard that is only plugged into the wall. A case could be made that could be excluded. And the seller could take that because it's not really attached to the land. It's just sitting there on top of a concrete slab with a wall plug in. And so what you need to be aware of is if you're representing the buyer or seller, and there's ever any question about some of these strange things like potted trees or shrubs or electronic car charging systems, which are more prevalent these days, security systems, video doorbells. We've actually had someone call because someone took their Ring doorbell. And that's considered actually real property because it's attached to the wall via a screw. But if there's any question about whether something conveys or doesn't convey, it is so much easier if you have it in the contract. Something like this happened happens all the time, but we talked about in the email, we went back and forth in the email, or it was also in confidential remarks in the MLS, etc. What is in the MLS does not apply to what is on the contract. The contract is the prevailing document.
So to put that another way, if you're a buyer's agent, don't check that box in P1 that says additional items included and type in there per MLS. That doesn't work because the MLS is just advertising. Items that are included in the sale have to be specifically listed. If you need to attach an addendum, you can do that. You can just check that box, say see ADM 1 and list the additional items. If you're a listing agent and you get an offer that says per MLS, remove that and say that, you know, the items have to be specifically listed. There's actually a CAR form called bill of sale that could be used for that, but more often the addendum is typically just used to list the items, or they're even just listed on a separate piece of paper and referenced as being included as a part of the purchase agreement terms.
All right, any questions on that?
I do have a question, please.
Sure.
Go ahead, Daya.
Can I check the box if I'm not sure they have this item or not? Like, let's say I couldn't really see electric charging system. The garage was, you know, filled with stuff. Can I check it just in case?
Yeah, but it would then be the responsibility of the listing agent to remove it in a counteroffer if it didn't exist. But yeah, I mean, if you believe it's there and your seller, or excuse me, your buyer wants it, definitely check it. And then you could even reach out to the listing agent and said, hey, is this there and are they taking it or is it included? And then, prepare the offer accordingly.
Okay, thank you.
You're welcome.
But my recommendation is if it doesn't have it, verify it doesn't. Don't check it just because you want to check it, because then here's where it will probably play out. The buyer thinks the seller is going to put one in.
Oh, okay.
Just because they check this box and it's not there doesn't mean the seller is required to put one in.
Another strategy with that as a buyer's agent is that if you put in a whole bunch of things that aren't applicable, it ensures that the seller is going to issue a counteroffer versus accept your offer as written. So there's that.
Do you mean to confirm that they don't have it in writing? Just to be sure.
You best to do that by email with the listing agent. Say, is there electric car charging system in the garage? And if the answer is no, then it's obviously not going to be included. If the answer is yes, then you say, is it included in the sale? Or you can just, check the box that says it's included, because your buyer wants it. Maybe your buyer doesn't want it because they don't have an electric vehicle.
Okay. Thank you.
I can't tell you how many agents in our office had to buy washers and dryers for their buyers because they thought they were going to be getting the washer and dryer and the agent forgot to check the box and the seller took it. Only takes one of those to really understand Section P of the contract. Ask Ricky Silver. All right, correspondence log. In the last few minutes that we have, this is something that is always a little challenge for agents to have put together, which is the correspondence log. So what is a correspondence log? Basically, it's a communication back and forth between you and your principal about any element of the transaction that could be deemed really important. And it's always important to have the verbal conversation and then back it up with an email clarifying the conversation that you had with that principal. And if there's ever a case where you can go back in, I can tell you, every case that I've probably ever dealt with, the agents lacked their communication logs. They didn't have one. And because of that, we probably lost the case. But that communication log can save you from saying, no, Mr. and Mrs. Buyer or Mr. Seller, I told you this we had this conversation on October 1st. By the way, here's the email that I sent you that you replied to that we had this conversation. So there's several sources to have a communication log. Mark makes the recommendation. A lot of our TCs use Folio, item number 3. It's a Chrome extension. And then the way it works is every time you send an email, you should always put the subject property address in the subject line. So when Folio goes in and pulls all those emails, it looks into the subject line of that property address and compiles everything. Is that right, Mark?
That's generally, correct. I'm not a Folio user. I've used this number 4 Cloud HQ, and I think that's a pretty good, program. Again, your TC is probably going to do this for you, but the way you can help your TC create this is to always use the property address in the subject line. So don't just say Walnut Street, say 123 Walnut Street, Unit 4, question about FHDS or whatever, don't just say question about FHDS. There's nothing in that subject line to tie it to your transaction. That email won't be picked up in the correspondence log. That's how you as an agent can help your TC to create a complete correspondence log.
By the way, I've dropped this complete presentation into the chat box. Eve has also sent it out as well. And the presentation will have all the links to everything we've talked about today, so you can easily access and come back. I can't speak enough about having a transaction log, transaction doc
Correspondence log.
correspondence file for each one of your transactions, because it's really your job and responsibility for the BRE to do that. On another note, I wanted to make sure too, from a safety concern as well too, that if you're not using a dedicated controlled server, then you should be using your KW email account for your business. Reason being is because it has a little bit more protection, two-party verification already put in place, but it's much more because it's an elevated email account. If you're using something like your own personal Gmail or Gmail you've created, or God forbid, I'm sorry, I'm going to say it, Yahoo or AOL or Microsoft Office, or what is it? What is Microsoft?
Office 365 Outlook.
No, the other one before that, MSN.
Oh, MSN.
God help you.
Hotmail. Yeah.
God help you. And here's why. They're not secure. They're not secure. And many of you well have seen that recently. I realized this too as well. I need to practice what I preach. And so my email that I want you all to use, matter of fact, I'm going to show it to you, and sending me anything, whether it's a digital signature, an email, etc., is robshantz@kw.com. Do not send it to my personal Gmail account moving forward. So if you haven't gotten that message, please adhere to that, because as broker, I want to have all my information secure from the brokerage standpoint. All right, we're a little bit over time. I appreciate everybody that held on. Hopefully you learned something today. Thank you for my counterpart, Mark, for being here. Everybody go out and have a great day.
See you next week.